Hi friends, my name is Jimmy Singh, broker owner of Supermax Realty, 647-961-2639, and my website is www.supermaxrealty.ca. So in this short video, I'm gonna discuss the implication, when somebody get divorced as for real estate sales, and unfortunately, they said couples who get married in Canada, roughly 38 to 40% get divorced. And I was reading an article yesterday at Toronto Sun. They said post-COVID, it is expected the divorce rate in Canada to rise 38%, and it can be very stressful, both emotionally and financially for the family, and especially the situation can be complex if you bring kids to the marriage, right? And over last 50 years, the law keep evolving as far as the separation agreements and the how the assets are split, especially if one of the parents stay at home, take care of the kids and family, because the law says if they are sacrificing their job or career for the sake of greater good for the family, they should be compensated because they don't have to pay childcare and all, right? So those things have to be cleared. And chances are, if you're watching my video on YouTube, unfortunately you might be getting divorced. You already have gotten divorced. So I hope this video will help. So first, what is a matrimonial home according to Ontario Family Law Act? So they said a matrimonial is any residential property where both spouse has interest or they live together. And you also have to understand, apart from your primary residence where you live, you might have a cottage up north. Let's say you live in Toronto and on the weekend you go to your cottage country. So that cottage can also be counted as matrimonial if you visit on weekends with your family. So talk to your attorney or divorce lawyer. I'm not a divorce lawyer. I'm a real estate broker practicing real estate in Greater Toronto area, Golden Horseshoe, London, Kitchener-Waterloo for last 15 years. So I'm just talking purely about real estate, what I learned dealing with clients in this situation over last 15 years. So as far as the law goes, they said both the spouses have equal rights as compared to matrimonial home, and then until it's sold or a judge grant a court order that one of the spouses to has to move out, and this is what we call exclusive possession. Maybe it's a situation is better, or maybe there's a violence or abuse involved. So court basically will tell one of the partners to move out, but this order is for a specific period of time, and certainly during that time a spouse can periodically re-enter, but they need to give reasonable notice, and it has to be order and for a specific purpose, right? And during this time, out of both the spouses, one spouse can't sell, refinance, or take line of credit or debt against the house without other partners' consent. So that is something you have to be aware of. And then let's say even if one person's name is not on the title, still both the parties have to sign, whether you bought the house before the marriage, and then after marriage the other person moved in. So law is very, very straightforward. And they said even if somebody give you house as a gift, it still is 50-50. Or even if you inherit, you get inheritance, until the inheritance, you take down payment and put toward the house, that is also something that basically is split 50-50. And obviously if your partners not 50-50, I mean, like, according to the law, they look at all the assets and basically decide according to income and other things. But you have to also understand, if somebody's parents give a deposit or down payment towards the kids and suddenly they get separated, those gift or the down payment, the other spouse is not supposed to, or they have no obligation to return the deposit. So court also looks into it. And obviously if it's an order of partition for sale is granted, the court basically order both of you guys to sell. So my tip to the clients is basically there's three solutions to that to avoid. First, you can either loan the money to your kid as on certain terms and conditions, just like a mortgage, and you can draft a binding agreement on them that they will pay periodically those payments, and the agreement can be drafted at the lawyer's office. And second thing is, some parents might keep their name on the title for a newlywed couple in some cases, That way, basically, they live there and they pay their parents a rent. Obviously, they have a house to live there. And in case, down something, a marriage breaks down, they don't lose the deposit and have to fight a battle in the court. Third thing is they can hold those assets in the trust, so that way for their kids, so that way the other spouse can't touch it. But again, talk to divorce lawyer. They are more in tune with the changes in law, and it is recommended there has to be prenup signed. That way your assets are protected, right? And then coming to a common law. So common law, basically they said if somebody is living as a partner for 3 years or more than 3 years, whatever you bring into the relationship, you can take the same thing out when a relationship breaks down. And you don't need a consent of other partner if you're selling a house, because you don't have same legal rights as a legally married couple in Ontario for now. But situations can change, the new laws can pass. And so guys, over years I have seen there's 4 things that happen, or 4 options when the time comes to sell the property because of the divorce. So first is you keep the property and you want to buy your spouse out. So I give you an example. Let's say your house is worth 600,000 and you owe a mortgage of 200,000. So basically there's 400,000 equity. So as your share is like 50-50. So let's say 200,000 you get, 2,000 your spouse gets. So what you have to do is you have to go to your bank to get qualified. And because right now your mortgage is 200 and you have to pay your spouse 200, so you have to borrow extra 200 to refinance or get a new mortgage. That way you pay off your spouse or partner, and then your mortgage obligation increase to 400,000. So that is something you have to be aware. But you understand that bank will requalify you, and they will ask separation agreement and other obligations that you have. So let's say you have a child support or all those things. So that is something you have to also consider. And second thing is, let's say you have an investment property prior to, let's say, getting married, and your property, let's say, is 400,000 before you got married, and now it is worth 700,000. So the court says whatever is the value prior, you get to keep that, and whatever is the growth, you again split 50-50 or as per the law. And in second situation, your spouse can even buy it. So same process, they have to go to bank and get qualified and all. Third thing is both you and your spouse wants to sell, or maybe rent, or maybe split the proceed. Again, a separation agreement has to be finalized before you sell the house. If it's not finalized, then a lawyer will hold the proceeds till the agreement is finalized by the court. So keep that in mind. So don't jump the gun and try to buy separate house until you have money in your pocket. Fourth thing can happen is both spouses by mutual consent says one person can stay in the house, take care of the kids, because they are going to a neighborhood, they don't want to disrupt their kids. So that also happens, but not many times. Or you can keep this as an investment property for your kids. So I recommend you to get an appraisal for taxation purposes, so when the person moves out, on that day it was residential, but once one partner moves out, then it loses the status of primary residence, and there might be some capital gain consequences. So talk to an experienced accountant or a lawyer who know what they're doing, and they'll be able to help you. And as far as the mortgage go, guys, again, as I said, you have to go to the bank, and bank require a separation agreement, and then based on that spousal agreement, they will qualify you and give you a new mortgage. And as far as the taxation goes, a land transfer tax, in some cases, one spouse, when they buy a house from their partner, and if there's no separation agreement formal in place, they might have to pay land transfer both to Ontario and for Toronto, or municipal and Ontario, which we call rollover. So that is something you also discuss with the experienced lawyer. And then people ask me all the time, what if I move out? Would I lose the right? You don't lose the right. You can continue living, and that is something you have to understand. And talk to a good lawyer. You don't lose the principal residence just because you move out. And lastly, if you have any questions, you can give me a call at 647-961-2639, or you can visit my website www.jimmysingh.ca. And I've been helping my clients sell real estate for last 15 years in Greater Toronto area, Hamilton, Kitchener-Waterloo, London. And thanks for watching. Have a blessed day.